We're all set? All right. I'm going to call this hearing to order, the August 22nd Code Enforcement Special Magistrate hearing, and I don't see any one that's going to be here that doesn't know the general rules of how we run the show, but I'll just briefly go over, just in case anyone looks at this later. We will have handled the openings. These are evidentiary hearings. Both sides are permitted to present testimony. Any items that are presented into evidence will remain here in evidence, and because the city has the burden of proof, the city will present its case first. Anyone who is here to speak on behalf of the cited individual or entity would be able to present its case after the city goes. There's cross-examination is permitted by both sides, and following the presentations, I'll make a decision and make that finding verbally and enter an order that will be mailed out and placed in the record. The hearings are recorded electronically, and so when the case is called, if you would please step to the podium and state your name clearly for the record. Anyone who is intending to testify today, if you would please stand and be placed under oath. Thank you. If you would raise your right hand. Do you swear or affirm that the testimony you'll offer today will be the truth and nothing but the truth? Thank you. Please be seated. All right. The first thing on the agenda, SunTrust Mortgage, case CE 13-001408. City of Oviedo.
Good morning, Your Honor.
Good morning.
Jim Orioles representing the city in case number 13-001408, 293 Crystal Circle in the city limits of Oviedo. Your Honor, Mrs. Vitale is giving you a packet of information, I believe. This is just a little bit different than normal. We don't have a property appraiser sheet with this case because the property appraiser's record has not been updated as yet. We notified the owner, Philip Hampton, and he notified us that his home had indeed been foreclosed. We got with the clerk of the court, and Your Honor will see the clerk of the court papers indicating that on June the 11th, the property was foreclosed on and is now in ownership of the bank.
The sale was completed?
Yes, ma'am.
And notice for the hearing?
Notice of violation, and we then sent the notice of violation to SunTrust Bank. SunTrust Mortgage. Got to put my glasses on here. On July the 23rd. It was signed for by SunTrust Mortgage, and you can see the picture that was taken the day of the notice of violation. Pool is in.
Let me ask you this. I'm sorry to interrupt you, but the packet that I've been handed, is that exactly the same as what you're testifying?
Yes, ma'am.
Okay, and would you like this packet to be moved into evidence?
Please.
As the city's composite exhibit A?
Please.
Okay. And hearing no objection, this will be admitted into evidence. Okay. And you said, I'm sorry, you were drawing my attention to, the card.
Yes, ma'am.
Okay.
Has been signed for. Your Honor will notice the picture was taken on the 6th of August of the pool, which is stagnant and a sanitary nuisance. We sent the notice of hearing. The notice of hearing was also signed for. Affidavit of violation request for hearing, and Your Honor, see the pictures that were taken this morning. There's been no change, and we have not been contacted by the mortgage company.
And so they got notice of the hearing. What date was that? Do you know? I'm looking at the green card, but I don't see.
No, there's no date on the green card. It was delivery address August 9th, it says here.
Okay. It looks like you, on the affidavit, you notified him back in July 23rd?
Yes, ma'am.
Okay, so it went back. When did you find it?
July 23rd is when we sent the notice of violation to SunTrust Mortgage.
Okay.
The original was on the 11th of July. The original inspection was on the 11th of July.
And then you notified who you...
We notified the property. Yes,
the
ma'am.
record
That
owner.
property owner notified us that his home had in fact been foreclosed on. We contacted the clerk of the court, who confirmed that, and we have the paperwork there.
Okay, so the violation was found on the 11th of July, and the notice of violation was sent to the correct owner,
On the 23rd of
SunTrust
July.
Mortgage, on the July 23rd?
Yes, ma'am.
Okay. And then notice of the hearing was signed for on August 9th?
Yes, ma'am.
All right, and it's your testimony that hasn't been corrected as of today's date?
Yes, ma'am, that's correct. I was out there this morning, took a picture this morning.
Okay, and I see that picture. So this has been 43 days that this has been out of code. All right, seeing no one here to testify on behalf of the property owner SunTrust Mortgage, unless you have anything else to offer,
No, ma'am.
I'm ready to make a ruling. Having considered the evidence and testimony presented, I'm going to make the following ruling, that the respondent is the legal owner of the property at issue, that being SunTrust Mortgage, that the city's provided proper notice of this hearing to the legal owner, that the city's met its burden of proof in establishing that the property at issue is not in compliance with the City of Oviedo's Code of Ordinances, and that the respondent shall have until, would you like to make a recommendation? I'm inclined to ask them to be in compliance before the next hearing. Okay. And the next hearing that we have is September 26th. So I would ask, or I'll find that the respondent will have until September 25th to bring the property into compliance, and failure to do so will result in a fine. We usually do $250 when it's a pool. Does the city have any objection to that, or any other recommendation? The city would agree to $150 in this case? Okay. Then the respondent will have until September 25th to bring it into compliance, and failure to do so will result in a fine of $150 per day for each day that the property remains in non-compliance. Hearing nothing else on that, that'll be the ruling, and I will issue a written order today. And that will be the end of the first case. And moving on now, we have a Massey hearing. Case CE 13-000669, and Madam Clerk, may I keep that as Exhibit A? Thank you.
All right, good morning, Your Honor. I'm Monica Cole, and this is CE 13-000669 for Circle K Stores, 40 West Mitchell Hammock Road on the city limits of Oviedo. Your Honor heard this case on June 20th, 2013 for violations of Sections 14.5A, specifically for erecting signs without first obtaining a permit from the city of Oviedo. Your Honor ordered that the respondent take corrective action by August 21st of 2013, or a fine of $50 per day would be imposed. I re-inspected the property this morning, August 22nd, and found it to be in non-compliance with your order. Your Honor will see an affidavit of non-compliance, has been filed with the code enforcement specialist, and staff requests that you find that the required corrective action to achieve compliance has not been taken by the required date, and that the fine of $50 per day be imposed beginning today, August 22nd, 2013.
Okay, and I have the original affidavit of noncompliance.
Yes, ma'am.
Would the city like this to be entered into evidence as Exhibit A?
Yes, ma'am.
Okay. Hearing no objection, that will be admitted into evidence. And is this, just for my clarification, is this where they had the car wash signs?
Yes, ma'am.
And they said that, and we gave them, I think, 60 days, didn't we?
Yes, I
think
believe
we went
so.
to
I
that
actually
class.
was on the phone with them yesterday afternoon and this morning. So they're hoping to have all of that removed sometime today.
Oh, good. Okay.
But as of right now, they have not. They have
Okay.
not done anything.
So I'll find that they are not in compliance with the order that was entered at the hearing 2 months ago, and that the fine of $50 per day that was assigned 2 months ago, that will begin to commence as of today.
Yes, ma'am.
And I'll enter the Massey order this afternoon.
Thank you, ma'am.
All right. And in case I didn't make it clear, just so that the record can reflect, there is no one here to speak on behalf of the Circle K stores. All right. If we have nothing else on code enforcement issues, then what we